Procedure, Reform and Modernisation Bill, second reading.
The Honourable Simon Powell.
Thank you, Mr Speaker. I move that the Criminal Procedure Reform and Modernisation Bill be now read a second time. Mr Speaker, the Criminal Procedure Reform and Modernisation Bill underlines this government's commitment to modernise New Zealand's justice system for the benefit of those who use it and are entitled to depend upon it. New Zealand's criminal procedure is outdated and cumbersome. The current system may be working well from the perspective of those who earn a living from it, but it is failing those who find themselves in our courts through no fault of their own. In the words of the late Chief District Court Judge, His Honour Russell Johnson, the lack of teeth in the current law has contributed to, quote, an unacceptable degree of indiscipline, inefficiency and delay within the criminal justice process, as well as, regrettably, injustice where exhausted witnesses have abandoned cases because of excessive time delays, end quote. This bill will fundamentally change criminal procedure, making criminal processes much more efficient and accessible. It will deliver timely justice and provide sufficient flexibility to meet contemporary and future expectations of court processes. Mr Speaker, we can never completely remove the distress and anguish that victims and their families experience as a result of offending against them. But through this bill, we can help them to move on with their lives by reducing and streamlining their exposure to the criminal justice system. I would like to thank Select Committee Chair Chester Burrows for steering the committee through this 600-odd page bill. The Justice and Electoral Committee recommended a number of sensible clarifications and refinements, all of which the government is adopting. The most significant changes recommended by the committee include widening the grounds for ordering a retrial for a defendant found guilty in their absence, clarifying that the court may not sentence a defendant in his or her absence for imprisonable offences, enabling costs ordered against a party for not complying with procedural requirements to be paid to people connected to the proceedings who incurred additional costs because of the non-compliance, removing the requirement that second appeals to the High Court and Court of Appeal must be on a question of law, and providing that leave for appeal may be granted if the appeal is in the interests of justice, removing the reverse onus provisions carried over from previous legislation that the Attorney-General concluded were unjustified under the New Zealand Bill of Rights Act, splitting the bill's single offence and penalty structure for publishing suppressed information into a two-tiered system to better reflect the levels of culpability relating to those actions, and removing the proposed offence concerning the liability of internet service providers for breaching a suppression order. Mr Speaker, the committee also recommended a number of minor and technical changes to the bill which have also been adopted. In addition to these changes, a number of further amendments have been made to the bill since it was reported back from Select Committee. To this end, I would like to thank the ACT Party, the United Future Party, the Māori Party and the Labour Party for their constructive approach to negotiations since the bill was reported back from Select Committee in July. Earlier today, I tabled a supplementary order paper, well actually three, but one in particular, which will give effect to the changes made as a result of those negotiations. I am confident the additional safeguards we have developed strike an appropriate balance between time and cost savings and a defendant's right to a fair trial. The main changes contained in the SOP are the removal of the requirement for the defence to identify issues in dispute pre-trial, setting the jury trial threshold at offences carrying a term of 2 years imprisonment and above, amending the clause giving the courts the ability to proceed in the absence of the defendant so that the court's discretion is limited to proceeding in procedural hearings where no determination of guilt or innocence will be made. With regard to substantive hearings, the bill will provide that if the court is satisfied that the defendant has a reasonable excuse for non-attendance, the trial must not proceed in the absence of the defendant unless it's satisfied the defendant will not be prejudiced by his or her absence. Amending the reference to cost orders to make it clear that cost orders against the defence or defence counsel for unreasonable and significant procedural delay are expected to be used rarely and only for significant procedural non-compliance, removal of the word substantial from the miscarriage of justice test, and restoring the current 6-month limitation period for the least serious Category 1 and 2 offences. Mr Speaker, I'm pleased to report to the House that, including the changes made in the agreed SOP, the reforms contained in the bill have the potential to free up to 9,000 court sitting hours each year by delivering benefits which include approximately 36,650 fewer court events, somewhere between 230 and 450 fewer jury trials, significantly a 6 to 9 week reduction in the average time to complete a jury trial, and millions of dollars in savings. In addition to the changes I have outlined, the bill will address concerns about name suppression for so-called celebrities by providing that there is no presumption of extreme hardship solely on the ground that the defendant is well known or famous or think they are. I am confident that this bill will ensure more timely justice for victims, witnesses and defendants, and will provide an enduring legislative framework for criminal procedure which will ultimately enhance public confidence in the justice system. I'd like to conclude, Mr Speaker, by saying this bill has been 10 years in the making. Various ministers of justice and courts over a long period of time have worked on this piece of legislation, and thanks go to them for trying to wrestle with this particular beast, which is not insubstantial in size and content. But in concluding, just to say that in the end, what we have is a piece of legislation which is going to be broadly acceptable to a vast majority of parties present in the House. And that is the way to move ahead with reform like this type of work, and I am quite willing to conclude today by thanking those parties who have been involved in those discussions, and by thanking the Ministry of Justice, the Law Commission, who acted as advisers on the bill. Mr Speaker, I commend this bill to the House.
The question is that the motion be agreed to. Charles Cheval.
Thank you, Mr.